Yes. Yes. I'm sure now that I gave him a piece of paper to read. He has started. Yes. Right. Yes. Yeah. In fact, very well.
Order number 1, administration of oath. Order number 2, communication from the chair. Order number 3, messages. Order number 4, petitions. Order number 5, papers.
Chairman, Budget and Appropriations Committee.
Thank you, Honorable Speaker. Honorable Speaker, I beg to lay the following paper on the table of the House today, Tuesday, 29th, it's not Tuesday, actually, it's Thursday, 31st, 2022. Report of the Mediation Committee on the County Government Grant Bill, Senate number 35 of 2021. I thank you, Honorable Speaker.
The Chairperson, Departmental Committee on Trade, Industries and Cooperatives.
Thank you, Honorable Speaker. Honorable Speaker, I beg to lay the following paper on the table of the House today, Thursday, 31st March 2022. Report of the Departmental Committee on Trade, Industry and Cooperative on its consideration of the National Electronic Single Window System Bill, National Assembly Bill number 15 of 2021. Many thanks indeed.
Very well.
Order number 6, notices of motion. Order number 7, questions and statements.
Honourable members, I rearrange today being a Thursday and noticing how we are operating. I rearrange business so that we go to order numbers 8, 9, and 10. Once we close that, I will even go to order number 2. Proceed that way.
Order number 8, procedural motion, reduction of publication period of a specified bill.
Chair, Budget and Appropriations Committee.
I thank you, Honorable Speaker. This is, as you have said, as earlier said, is a procedural motion to reduce or sorry, Honorable Speaker. I think I'm handling so many things at the same time, Honorable Speaker. Honorable Speaker, I beg to move that notwithstanding the provisions of Standing Order 120, this House resolved to reduce the publication period of the Supplementary Appropriations Bill, National Assembly Bill number 14 of 2022 from 7 days to 1 day. Honorable Speaker, this House is aware that we did the report on the supplementary budget on Tuesday, Honorable Speaker, and owing to the urgency of resources to be disbursed, Honorable Speaker, including the CDF, Honorable Speaker, including the intervention that the government has done on fuel and also the drought that is in the country, beseech this House that we reduce the publication period from the 7 days to 1 day. I thank you. I beg to move and request the Majority Leader to second.
Honorable Kimunya.
Yeah, Honorable Speaker, I think the facts speak for themselves. I raise to second and ask the House that we support this initiative and indeed go through all the processes today so that we can unlock the resources that are required for taking our country forward. I beg to second.
Honourable members, I propose the question, which is that notwithstanding the provision of Standing Order number 120, this House resolves to reduce the publication period of the Supplementary Appropriation Bill, National Assembly Bill number 14 of 2022, from 7 days to 1 day. Very well, as the House desires, I put the question, which is that notwithstanding the provision of Standing Order 120, this House resolves, sorry please, I can't. Member for Mumias East, please, let's just finish this business. I repeat, I put the question, which is that notwithstanding the provision of Standing Order 120, this House resolves to reduce the publication period of the Supplementary Appropriations Bill, National Assembly Bill number 14 of 2022, from 7 days to 1 day. Will as many as for that opinion say aye? Aye. Will as many as for the contrary opinion say nay? The ayes have it.
Order number 9, the Supplementary Appropriation Bill, National Assembly Bill number 14 of 2022, first reading. A bill for an act of parliament to authorize the issue of certain sums of money out of the consolidated fund and the application towards the service of the year ending on the 30th of June 2022, and to appropriate those sums for certain public services and purposes.
Honourable members, even those members who are coming in for 2 minutes, I thought what was just said a while ago by the little majority, I thought that that should be reason enough for us to sit through. Because all of you are talking about things to do with the constituency, what. The little majority appealed that he hopes that we will sit through. Yeah, I know there are some who don't have capacity to sit in the house for more than 10 minutes. But please, on this one, but they will be out there shouting that they have passed this and this other law. And I can see them there outside there on their way out. Please, we know that you have commitments in the constituency, but this, I think, is very important to all of you. Indeed, even to the institution of parliament. So please, let's just today spare some little time. Stay for at least 1 hour. Until, yes, exactly. The Honorable Pukosa says until we are through with order number 12. Next order.
Order number 10, motion, report of the Committee of the Whole House on its consideration of the Health Laws Amendment Bill, National Assembly Bill number 2 of 2021.
Now those ones have left. Member for Malava, please. You see, please don't leave. You know, you leave, and at the end of the day, the Constitution has said that you cannot pass some of these things unless you have quorum. Just tell your colleagues, please, just take kidogo. Honour members, report on this, the debate on this motion was concluded in the Committee of the Whole House, and what report remained was the question to be put about agreement with the committee. I therefore put the question, which is that this House do agree with the report of the Committee of the Whole House on its consideration of the Health Laws Amendment Bill, National Assembly Bill number 2 of 2021. Will as many as of that opinion say aye? Aye. Will as many as of the opinion say nay? The ayes have it. Where is the mover?
Yeah. Honourable Speaker, I beg to move that the Health Laws Amendment Bill, National Assembly Bill number 2 of 2021, be now read at that time. And I want to thank the many members who have contributed over this bill. It's gone through like 3 public participation sessions. It's just over 1 year old, but at last we have brought it to or we're just about to bring it to a conclusion so it can find its way into the Senate. And particularly I also want to thank the Committee on Health and all the people who appeared before that committee to make this bill what it is today. I beg to move and I request the Honorable Wangwe to second.
Honorable Wangwe.
Thank you, Honorable Speaker. Honorable Speaker, I do second.
I propose the question, which is that the Health Laws Amendment Bill, National Assembly Bill number 2 of 2021, be now read at that time. The desire of the House that I put the question, having confirmed that the House still corrects, I proceed to put the question, which is that the Health Laws Amendment Bill, National Assembly Bill number 2 of 2022, be now read a third time. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
A bill for an act of parliament to make amendments to health-related laws.
Honourable members, we go to back to order number 2. Before we go back to order number 7, honourable members, it's communication from the chair. You recall that during the afternoon sitting of this House on Tuesday, 29th March 2022, the member for Garissa Township, the Honorable Inde Duale, rose on a point of order and raised a number of questions of constitutional propriety of the first supplementary estimates for the financial year 2021-2022 as presented to the House for approval by the Cabinet Secretary for the National Treasury. The Honorable Duale noted that whereas Article 223 of the Constitution allows the Executive to utilize monies that are yet to be appropriated by the House, the same is subject to a maximum of 10% of the approved estimates of the particular financial year on each vote, and the strict conditions of the timelines within which the Cabinet Secretary must seek the approval of the House. It was then Honorable Duale's submission that the supplementary estimates presented by the Cabinet Secretary did not adhere to the strict timelines imposed by Article 223 of the Constitution. To buttress his claim, he contended that no approval of the monies used was sought either within 2 months of their first disbursement or at least 2 weeks after the resumption of the House from a recess as contemplated under Article 223 of the Constitution. The Honorable Duale also asked the House to note that Article 223(4) of the Constitution only allows the introduction of an appropriations bill for money spent, yet the request for approval from the Cabinet Secretary for the first supplementary estimates for financial year 2021-2022 includes the potential appropriation of monies yet to be spent. This, he disputed, essentially constitute new undertakings by the National Executive at an advanced stage of the financial year. The member also contended that these actions of the Cabinet Secretary, and by extension the National Executive, did not accord to the letter and the spirit of the Constitution. Section 43 and 44 of the Public Finance Management Act 2012, which imposed limitations on accounting officers to reallocate appropriated funds and the responsibilities of the national government in submitting a supplementary budget, respectively. Regulations 40 of the Public Finance Management National Government Regulations of 2015 on the responsibilities of each accounting officer of the national government when submitting items related to supplementary budget estimates. Honourable members, in the ensuing debate, several members were in support of the point raised by the Honourable Duale, including the Honourable David Sankok, the Honourable Didi Nyoro, Kimani Ichung'wah, and George Murugara, who beseeched the Speaker to make a ruling on the matters before proceeding with the debate on the estimates. On their part, the leader of the majority party, the chairperson of the Budget and Appropriations Committee, and the Honourable Mark Nyamita, a member for Uriri, urged the Speaker to allow debate on the motion for approval of the first supplementary estimates for financial year 2021-2022 on the basis of the past practice and precedent of the House in dealing with supplementary estimates submitted to the House, noting that issues such as those raised by the member for Garissa Township have either not been previously raised or have been unanimously overruled by the House when raised. Further, the leader of the majority party offered an interpretation to Article 223, Clause 5 of the Constitution with respect to the scope and what constitutes the 10% limit imposed on the sum of expenditure under supplementary appropriations, an interpretation which I must admit is most persuasive, as opposed to the claim that the constitutional limit is imposed on each vote. Honourable members, as I previously held and upheld the rulings of my able predecessors, a question of the constitutionality or otherwise of any matter under consideration by the House may be raised at any stage of its consideration, as the Constitution obliges the Speaker to respect, uphold, and defend the Constitution. This obligation is further expressly outlined in Standing Order 47.3 relating to instances which the Speaker may declare a motion inadmissible for being unconstitutional. While allowing resumption of the debate on the first supplementary estimates for financial year 2021-2022, I did reserve the delivery of a ruling on the matter to today on account of the urgency of the business in question, and bearing in mind that the approval of the motion on supplementary estimates is not the end of the process. Indeed, as the House is aware, the approval of such motion is followed by the consideration of the necessary supplementary appropriations bill. Honourable members, I note from the outset that I previously guided that with regard to the constitutional propriety of matters before the House, the obligation of the Speaker is circumscribed to procedural aspects and facilitation of the proceedings of the House. Any attempts by a Speaker to address the substantive legal aspects of such business would at the very least be a usurpation of a role reserved for the High Court under Article 165, Clause 3 of the Constitution. Therefore, honourable members, in addressing the point raised by the Honourable Duale, I shall limit myself to the procedural aspects relating to the first supplementary estimates for financial year 2021-2022 as presented by the National Treasury and the need to guide the House on its consideration of the business relating to the supplementary estimates. Honourable members, Article 223 of the Constitution provides as follows with regard to supplementary appropriations, and I quote, Clause 1, subject to clauses 2 to 4, the national government may spend money that has not been appropriated if A, the amount appropriated for any purpose under the Appropriation Act is insufficient or a need as a reason for expenditure for a purpose for which no amount has been appropriated by that act, or B, money has been withdrawn from the contingencies fund. The approval of Parliament the approval of Parliament for any spending under this article shall be sought within 2 months of the first withdrawal of the money, subject to Clause 3. Clause 3, if Parliament is not sitting during the time contemplated in Clause 2, or is sitting but adjourns before the approval has been sought, the approval shall be sought within 2 weeks after it next sits. Clause 4, when the National Assembly has approved spending under Clause 2, the appropriations bill shall be introduced for the appropriation of the money spent. Clause 5, in any particular financial year, the national government may not spend under this article more than 10% of the sum appropriated by Parliament for that financial year, unless in special circumstances, Parliament has approved a higher percentage. Honourable members, you may agree with me that the member for Garissa Township that the provision is quite clear on the threshold to be met by the Cabinet Secretary for the National Treasury in making any submissions to the House that may require the approval of a supplementary appropriation over and above the sum appropriated by the House arising from the annual estimates. However, whereas Article 223 of the Constitution imposes strict conditions on how the national government may spend money that has not been appropriated, it also prescribes timelines within which the approval of the House should be sought and caps the maximum amount that may be so spent. It does not make any further provision with regard to what is expected of Parliament thereafter, apart from noting that the House may, by resolution, increase the limit of additional spending allowed. The article does not set a limit within which the House is to grant or deny the approval. Honourable members, I further do note that in line with the settled House practice, the first supplementary estimates for financial year 2021-2022 were tabled in the House by the leader of the majority party on 1st of February 2022. In keeping with the requirements of standing orders, they were referred to the Budget and Appropriations Committee. The committee was expected to conduct public participation and engage the departmental committees and the National Treasury in order to make relevant recommendations to the House. A perusal of the schedule to the first supplementary estimates for financial year 2021-2022, incorporating the recommendations of the committee, indicate that the net sum contained is a request to the House to approve the expenditure of Kenya shillings 139 billion 752 million 936,287. When compared to the sum figure of 1.942 trillion approved in the budget estimates for financial year 2021-2022, the supplementary figure constitutes approximately 7% of the approved estimates. This at face value seems well within the 10% threshold set by the Article 223, Clause 5 of the Constitution. Let me resume my seat to allow those members to make their way in. I took my seat to allow you to come in. Now you. Is that one you made your way in? Very well, I continue. Honourable members, what therefore remains in contention is whether the submissions from the National Treasury adhere to the constitutional timelines relating to supplementary estimates, and whether the House should approve additional expenditure of monies on projects and undertaking not contained in the approved estimates for the financial year 2021-2022. The report of the committee, while recommending approval of revised proposals by the National Treasury, does not delve into the issue of the contested timelines. Honourable members, though I note that with regard to previous supplementary estimates that the National Treasury has invariably submitted most requests for approval of spending of monies not appropriated by the House pursuant to the limits under Article 223, I have perused the records of the House and confirmed that my office is not in receipt of any such request with regard to the first supplementary estimates for financial year 2021-2022. Honourable members, the question before the Speaker at this stage is, should this anomaly now vitiate the process already undertaken by the Budget and Appropriations Committee, the departmental committees, and indeed change the entire course of the first supplementary estimates for financial year 2021-2022, which now awaits consideration of the Supplementary Appropriations Bill? I am of the considered view, honourable members, that whereas the Cabinet Secretary for the National Treasury has evidently failed to meet the prescribed timelines with respect to the seeking of approvals for the first and subsequent withdrawals, consideration of the propriety of the supplementary items as submitted and the attendant legislation remains a task that this House cannot escape. Presently, the standing orders of this House do not guide on the form and manner in which the National Treasury seeks approval of the expenditure in excess of the approved estimates, and how several of such requests should be processed by the House pending the submission of the consolidated supplementary estimates. Additionally, no procedure is currently in place on how to request a request made outside the timelines prescribed under Article 223 of the Constitution should be treated. Honourable members, noting the lack of an express procedure, it would therefore be unfair for the Speaker to arrogate to himself the sole responsibility of a matter that is legislative in nature. You will recall that Article 124 of the Constitution requires the House to make rules for the orderly conduct of its proceedings. The Speaker may only refer to Standing Order Number 1 relating to matters not provided for, to provide guidance where no procedure is prescribed by the House. Pursuant to Standing Order Number 1, honourable members, I am therefore persuaded to allow the House to conclude the process of approval of the first supplementary estimates for financial year 2021-2022 by way of consideration of the Supplementary Appropriations Bill 2022, which is now before the House and which has just been read for the first time. I have chosen this option largely for three critical reasons. First, Article 259(1)(d) of the Constitution requires any person interpreting the provisions of the Constitution in a manner that contributes to good governance, any determination made with regard to the matter before this House ought not to terminally imperil the financing of government on account of administrative laxity or inaction. Secondly, I'm not aware whether the Cabinet Secretary has indeed been interrogated by the committee on the failure to adhere to the timelines relating to the requests made to this House, and whether the restricted timelines for considering the estimates allow the House adequate opportunity to obtain the required information. Thirdly, honourable members, as a non-voting member of the House, it would be imprudent on the part of the Speaker to solely allow what is essentially a procedural technicality to override the important objectives intended to be achieved through the consideration and approval of the supplementary estimates. The House seems to have bolted at this stage, and the House must resolve this matter one way or the other. The ultimate authority on the matter lies with the House, particularly this House. Honourable members, my reading of Article 223 of the Constitution requires this House to make a decision on any requests made by the national government that are outside the estimates approved by the House and the monies appropriated to finance the operations of government. Honourable members will recall that Article 206, Clause 2 of the Constitution grants the House the primary role of authorizing the withdrawal of any monies from the Consolidated Fund through legislation. Any request for withdrawal of monies from the Consolidated Fund, all approval of monies spent from the fund without prior authorization may also only be done by the House. Similarly, any authorization given to the national government or the manner it may request authorization for spending squarely lies with the House. Once again, I stop there to allow those members to make their way in. I allowed members to make their way in. I see others are taking off. There's a member for Kakamega. She has finished today's legislative work. The member who is, please just make your way in. You will deal with attendance matters. You can come to the front. It is not injurious. The people who sit in the front are not harmful to you. That's Honorable Sonkuya, is that so? And those other members who like sitting, is it near the toilets? So that they can sneak out. Please, now you can see there are quite a number of spaces out here. You don't have to hide at the back. Please come. I'm sure that's a member for Webuye West, is it? How don't you know the Honorable Dan Wanyama at his height? You know, you can see that now the Honorable Kamoti is just making his way, then somebody as a villager has called him. So he stops there to take the call. We'll proceed, honourable members. My direction that the consideration of the supplementary estimates and the supplementary appropriations bill continues does not excuse the failings noted with regard to the supplementary estimates presented to this House. The obligations imposed on the Cabinet Secretary in their interactions with the House should not be taken lightly. I do remind the Cabinet Secretary for the National Treasury to strictly adhere to the timelines affecting any supplementary estimates presented to this House. Administratively, and to prevent any future non-compliance, I do direct that the clerk maintains a specific register for noting any request for approval made by the Cabinet Secretary for the National Treasury pursuant to Article 223 of the Constitution, and facilitate the timely tabling of all such requests before the House. Each request must be reported to the House by the Budget and Appropriations Committee, which must confirm compliance of such requests with the timelines prescribed under Article 223 of the Constitution. This administrative request, honourable members, is to be referred. This administrative direction is to be referred to the Procedure and House Rules Committee to consider its inclusion during the revision of the standing orders. Honourable members, decisions of the House granting or denying approval sought under Article 223 should be specific and unequivocal. To aid the House to make such decision, the National Treasury should separate expenditures under Article 223 of the Constitution from any ordinary reallocations and all additions for each vote under separate schedules. With respect to spending under Article 223, the schedule should also indicate the amount and the purpose under each vote and item. The report of the Budget and Appropriations Committee on the examination of the same should also separate these two, in addition to the schedules of financial and policy resolutions. Further, since the Constitution expects the National Treasury to seek approval of the House within 2 months after the first approval, in the future, the House will be at liberty to consider the approval ahead of the supplementary estimates for the particular year and consolidate the two at the relevant legislative stage, including at the stage of publication of the attendant supplementary appropriations bill. Honourable members, with regard to the lacuna that is evident in the procedures of the House, I will, as directed, refer this matter to the House Procedure and House Rules Committee. The committee should recommend suitable text to codify the aforementioned procedures for processing requests from the National Treasury, including the registration, noting, and reporting of the requests to the House, and the scrutiny of the compliance of the requests with the prescribed timelines by the Budget and Appropriations Committee. I also thank the member for Garissa Township for raising this matter and the members who contributed to the ensuing debate for their valuable insights that undoubtedly shall enrich future interactions between the House and the Executive with regard to budgetary matters. Honourable members, in summary, it is therefore my considered finding that 1, the request to the House to approve the additional expenditure of Kenya shillings 139,752,936,287 when compared to the sum of shillings 1.942 trillion approved by the budget estimates for the financial year 2021-2022 constitutes approximately 7% of the approved estimates, which at face value is well within the 10% threshold set by Article 223, Clause 5 of the Constitution. 2, that since Article 259, Clause 1, Paragraph D of the Constitution requires any person interpreting the provisions of the Constitution to do so in a manner that contributes to good governance, it won't be imprudent on the part of the Speaker to allow a procedural technicality to override the important objectives sought to be achieved through supplementary estimates. In this regard, pursuant to the provision standing under number 1, the House shall continue with the process of approval of the first supplementary estimates for financial year 2021-2022 by way of consideration of the Supplementary Appropriations Bill 2022, which is now in its second reading. 3, that the Cabinet Secretary for National Treasury must, going forward, strictly adhere to the timelines required with respect to any future supplementary estimates submitted to the House. 4, that in future, the decision of the House granting or denying approval sought under Article 223 must be specific and unequivocal. To aid the House to make such decision, the National Treasury must separate expenditures under Article 223 of the Constitution from any ordinary reallocations and or additions for each vote under separate schedules. With respect to expenditures under Article 223, the schedules must also indicate the amount and the purpose under each vote and item, and when the first withdrawal of the same money was made. The report of the Budget and Appropriations Committee on the examination of the same must also separate these two, in addition to the schedules of the financial and policy resolutions. 5, that since the Constitution expects the National Treasury to seek approval of the House within 2 months after the first approval, in future, the House will be at liberty to consider the approval way ahead of the supplementary estimates for the particular year, and thereafter consolidate the two at the relevant legislative stage, including at the stage of application of the attendant supplementary appropriations bill. 6, that to avoid any future non-compliance, the clerk shall maintain a specific register for noting and any requests for approvals made by the Cabinet Secretary for the National Treasury pursuant to the provisions of Article 223 of the Constitution, and facilitate the timely tabling of all such requests. 7, that each request must be reported to the House by the Budget and Appropriations Committee, which must confirm compliance of such requests with the timelines prescribed under Article 223 of the Constitution. And 8, finally, that to address the lacuna in the procedures of the House in its ongoing review of the rules of procedure of the House, the Procedure and House Rules Committee urgently interrogates the provisions of Article 223 of the Constitution and propose relevant text for inclusion in the standing orders to codify the aforementioned procedure for processing requests from the National Treasury for approval of additional expenditure. The House is accordingly guided. I thank you, honourable members. Questions? First question is by the member for Luanda, the Honourable Mulele.
Thank you, Speaker, for that wonderful ruling. And this is a rise to ask question number 93 of 2022 to the Cabinet Secretary for Foreign Affairs. 1, could the Cabinet Secretary state the steps the ministry is taking to facilitate the return to Kenya of one Miss Beatrice Ayoro, holder of passport number BK 198627, who was working as a domestic worker in Najran City in Saudi Arabia, but is currently sick and confined in a house with no means of communication with her family members. 2, could the Cabinet Secretary also explain the action being taken against the directors of Messrs. 2-Star Safaris Limited, located on the 6th floor, Pioneer Plaza, Kenyatta Avenue in Nairobi, the agency responsible for the recruitment and placement of Ms. Ayoro to Saudi Arabia for failing to facilitate her return to Kenya. 3, what steps is the ministry taking to provide a lasting solution to the rampant cases of violence and inhuman treatment of Kenyans working in the Middle East, particularly in the Kingdom of Saudi Arabia? Thank you, Speaker.
Question will be replied to before the Departmental Committee on Defense and Foreign Relations. Member for Taita Taveta, the Honorable Lydia Mzigi.
Thank you, Mr. Speaker. I stand to ask the question number 094 of 2022 to the Cabinet Secretary for Labor and Social Protection. 1, could the Cabinet Secretary state the criteria used to identify and registration of elderly persons to benefit from the Older Persons Cash Transfer Fund program in Taita Taveta County? 2, could the Cabinet Secretary explain why data for a larger number of older persons registered under the program in the county since 2017 is yet to be captured in the system, therefore denying them benefits of the said program? 3, could the Cabinet Secretary undertake to ensure that all the elderly persons in Taita Taveta County registered under the program are duly enrolled and paid accordingly, including arrears accrued since their registration, without undue delay? And 4, what measures has the ministry put in place to ensure that all the eligible elderly persons aged 70 and above in Taita Taveta County are duly registered and receive their payment accordingly? I thank you, Mr. Speaker.
The question will be replied to before the Departmental Committee on Labor and Social Welfare. The next question is by nominated member, Honorable David Olesankok.
Thank you very much, Honorable Speaker, and thank you for that very wise, well-researched ruling that you have given that can only be equated to the Solomonic ruling or the Supreme Court ruling today that declared BBI dead as a dondo. Honorable Speaker, I rise to ask question number 095 of 2022 to the Cabinet Secretary for Interior and Coordination of National Government. 1, could the Cabinet Secretary state the total amount of money collected per county as fine from the motorcycle or border riders crackdown carried out across the country during the month of March 2022, and particularly starting from Tuesday, March 8th, 2022. 2, considering that there are over 2 million motorcycles registered and operating in Kenya, which thus translate to over 35 billion Kenya shillings if half of them paid the 35,000 shillings fine. Could the Cabinet Secretary indicate the specific government agency or department to which the said monies are sent, including precise appropriation in aid? 35 billion was enough to buy watermelon into Azimio la Utapeli. Yes. 2, 3, could the Cabinet Secretary confirm that indeed the said monies have since been reflected in the National Treasury? And if yes, indicate under which vote and how they have been utilized. Thank you very much, Honorable Speaker.
But you say the fines were imposed by courts of law, isn't it? Yeah. The fines were imposed by courts of law, and it's not. It's in very rare circumstances that fines would be treated as A&A. But you're asking for specifics, precise appropriation in it. Well, but you want this question to be answered by the Departmental Committee on Administration and National Security. Now, it's your choice. It's your choice. Interior. Very well. The question will be replied to before that committee, Departmental Committee on Administration and National Security. The next question is by the member for Emohaya, the Honorable Omboko Milemba.
Thank you, Honorable Speaker, for giving me this chance. But let me also make a quick comment that your decision was very wise, especially because it went for the holistic good of everyone and the country, given that we need that supplementary budget. Honorable Speaker, I rise to ask question number 096 of 2022 to the Cabinet Secretary for Interior and Coordination of National Government. What measures is the ministry putting in place to ensure that a civil registration center is established in the Mohaya constituency to facilitate service provision to the large population in need of registration services in the area, considering that the only registration center that serves the area is located 35 kilometers away in Mbale town and is overwhelmed as it also serves the residents of Amisi, Sabatia, Vihiga, and Luanda constituencies. Number 2, Honorable Speaker, could the ministry consider ensuring that each sub-county, rather constituency in Kenya, has a civil registration center with adequate staffing? Thank you, Honorable Speaker.
Fred, a question will be replied to before the Departmental Committee on Administration and National Security. Last question is by the member for Mwatate, Honorable Mwandime.
Thank you, Honorable Speaker. Question 97 of 2022 to the Cabinet Secretary for Transport, Infrastructure, Housing, Urban Development, Public Works. 1. What is the status of construction of the Mtomogodi Undani-Bura Road in Taita Taveta County? 2. Could the Cabinet Secretary explain why the construction of the road has stalled, yet funds had been allocated, and indicate when the construction works will resume? 3. Could the Cabinet Secretary state the expected completion time for the said project? Thank you, Honorable Speaker.
It will be replied to before the Departmental Committee on Transport and Public Works. Statement by Leader of Majority.
Honorable Speaker, pursuant to the provisions of Standing Order number 44-2A, I rise to give the following statement on behalf of the House Business Committee, which met on Tuesday, the 29th of March, 2022, to prioritize the business for consideration. Honorable Speaker, as members are aware, we've had a very protracted process in the consideration and approval of the report on the Budget and Appropriations Committee on the supplementary estimates for the year 2021-2022 financial year. And I'm happy that we're able to move this process forward, and I want to thank you for your considered communication on this. And a number of the publication of the Supplementary Appropriation Bill, which has already been read a second time to actualize the financial provisions made. I urge the House to expedite this process to finality today through passage of the said bill. Honorable Speaker, however, I wish to underscore that this is a very busy season for the House, in addition to the ongoing activities outside Parliament. And as members will appreciate, we still have the conclusion of the Division of Revenue Bill 2022, which is at the Senate, the County Allocation of Revenue Bill 2022, consideration and approval of the budget estimates for the fiscal year 2022-2023, and the Finance Bill for 2022 ahead of us. There may also be other bills that need to be expedited before the Sendai recess, which is lately just about 2 months from today. In this regard, I wish to encourage members and committees to expedite any urgent business to give the House adequate time to consider and process the matters. Honorable Speaker, on Tuesday next week, the following business has been scheduled for consideration, and in a committee of the whole House, we will be looking at the Universities Amendment Bill of 2021, and if the coffee bill is not completed or processed today. We will also be looking at the second reading of the following bills: the National Electronic Single Window System Bill of 2021, the Huduma Bill 2021, the Children's Bill 2021, the Advocates Amendment Bill 2021. Madam Speaker, I'm reliably informed that there are no questions scheduled to be answered by Cabinet Secretaries in the coming week. And once the chairpersons finish consolidating the questions, I shall report on that next week. Honorable Speaker, the House Business Committee will reconvene on Tuesday, the 5th of April, 2022, to schedule the business for the rest of the week. I now wish to lay this statement on the table of the House. Thank you, Honorable Speaker.
I see that some members who are put in interventions, but just on our members to plead with ourselves that if we know the process is, if the House approves the supplementary appropriations bill, both in second reading and committee of the whole House, then it will be read a third time, and that will conclude its consideration. But remember, it has to be taken to the government printer for printing, and thereafter, the warrants. You know, people think that you just pass the bill and then the money starts flowing. Then there will be warrants, which will be drawn by the National Treasury, so that some of the issues that you have been raising It is those warrants which we will now authorize the withdrawals. But they have to be based also on the authority of the Supplementary Appropriations Bill, which is the reason why we were appealing to as many of you as possible to at least remain around so that you can finish this. Because if you push it to next week, it also delays some of the things that you yourselves may want to. And I've got an indication that if we conclude by tomorrow, the process of assent and the signing of the warrants can be completed. So that then you begin doing your other things, including sorting out your constituencies and others as soon as possible. So even though I see a few of you have put requests, interventions, please make sure that your intervention will not go beyond 2 minutes. And we'll ask the clerk to make sure that 2 minutes. I see the member for Nyando has an intervention.
Honorable Speaker, thank you for the opportunity. I regret taking you back. As you were reading the ruling, Honorable Speaker, I was pricked to say something, and that is by applauding you for such a very important ruling that you've come up with. We had found ourselves in a ditch, going by the question raised by Honorable Aden Duale. But I thank you for wiggling out of this impasse that had the potential to create a gridlock for the entire country. And Honorable Speaker, one thing that I really appreciate is your recognition of Article 159 of the Constitution, that justice shall be administered without undue regard to procedural technicalities. And I thank you for bringing that forth and for creating a pathway going forward that we shall not be in such a similar ditch. But I also reckon that coronavirus may have also interfered with our calendar to a larger extent, and that calls for extraneous circumstances and therefore extraneous interventions, Honorable Speaker. So we may have overlooked certain things, not because we really wanted to, but circumstances dictated so. And I thank you, Honorable Speaker.
Member for Endebess.
Thank you, Honorable Speaker. Honorable Speaker, as the House Business Committee reconvenes next week on Tuesday, my prayer is that I have a bill, Honorable Speaker, which has taken long, the Kenya Food and Drugs Authority, which is a very important bill. And it will be an injustice to this nation if that bill is not sorted, because it is now at the committee of the whole House, and I would wish that it be scheduled. Secondly, Honorable Speaker, based on today's Supreme Court ruling, I also had a referendum bill which has gone through the Budget and Appropriation Committee, and it has been approved. So I would wish that also the referendum bill be scheduled by the House Business Committee, because I think it's a very important bill, so that in future, when we decide to do a referendum, then we need to have a law that can guide the process. Thank you, Honorable Speaker.
I say, what? Honorable Sankok, you also have an intervention? That was the original one?
Yes, because I just wanted to congratulate you for that ruling and still say that it was a very wise ruling. We love it as Kenyans, and we really respect the ruling, but the House Business Committee should also expedite most of the bills, Honorable Speaker. And Honorable Speaker, again, the ruling in the Supreme Court also concur well with you, as it is a very good ruling. We thank the judges. You know, BBI, the Handshake Brothers love you, but Kenyans hated you more. Rest in peace, BBI.
So now, honourable members, I think this is not the right forum, is it? Honourable Ndidi Nyoro.
Thank you very much, Mr. Speaker. And I rise on a point of order, Mr. Speaker, to seek your indulgence. I know this is not procedural, And that is why I am seeking for your indulgence through the standing order number 1, that today we have had a monumental ruling by the Supreme Court of Kenya, Mr. Speaker, and this is a process that actually even came to this House. Mr. Speaker, I'm seeking your indulgence that we have a motion of adjournment for a few minutes for us to be able to ventilate and congratulate our judiciary following the very good ruling, Mr. Speaker, that has happened today. As we are aware, as the citizens of Kenya, this process, Mr. Speaker, from the onset, has been marred with a lot of unconstitutionality, Mr. Speaker. A lot of public funds have been spent through this process, Mr. Speaker. And also, the ruling today, Mr. Speaker, that the president is immune. Mr. Speaker, that does not also confer immunity to the many public servants who were engaged in this illegal and unconstitutional process, Mr. Speaker, like one PS of Interior who came out and told Kenyans that they are going to swallow this process like malaria queen. That is why, Mr. Speaker, I'm seeking for your indulgence for us to be able to ventilate, congratulate our judiciary for this very good ruling that has happened today, Mr. Speaker, by putting a stop to the BBI reggae and shenanigans, Mr. Speaker, and the conmanship that wrapped the entire process. Mr. Speaker, I seek for your indulgence under standing order number 1 that we ventilate, Mr. Speaker, and put our voice on this very important ruling.
Honour members, but you know, standing order number 1 only applies where there are no specific provisions. If you had intentions of moving a motion of adjournment, you need to have brought it to the Speaker, and you know within which timelines. So I'm surprised the member for Suba South, North, is saying yes. He's saying yes all of a sudden, and I know how to be a strict observer of the rules. So Honorable Dede, unfortunately, it can't happen now. So, but of course, nothing stops any of you, even outside on the streets, to go and congratulate. We have a media house. We have the media center also here. Honorable Tiende Molo. Even that of the Honorable Tiende Molo, I think, is not working. Give him, it's not working from here.
Thank you. Mr. Speaker, because the Supreme Court decision appears to excite a number of members, especially those who do not understand the law, like Honorable Sankok, allow me to inform the Honorable Sankok that contrary to his celebration, he should actually be mourning, because out of 7 fundamental points, the Supreme Court allowed 5 grounds. Of fundamental importance is that it has set the stage for reggae to resume immediately after the elections. Thank you.
I think, honour members, let's not you are introducing a language that is not applicable in the House. Reggae. Now, you are doing some jig.
Thank you, Mr. Speaker. Mr. Speaker, let me lend my voice also to this a little bit. And Mr. Speaker, I just want to say that sometimes it is sad when people don't actually understand the import. Mr. Speaker, the most dangerous concept that was raised in that process was the issue of the basic concept. If the courts had allowed basic concept the basic structure concept or doctrine, Mr. Speaker, reggae would be as dead as a dodo. Because, Mr. Speaker, the basic structure concept says that it was actually equating the application or making the Constitution to be a Bible or the Quran. that cannot be amended at all. And Mr. Speaker, except by judges, Mr. Speaker, what the judges have said is do it right, and reggae is back on. So all we need to do is go on in August, and reggae is back.
Sorry, no, but you can't. Now I'll hear the last one. I'll hear the last one from the member for Kitui South. But who are you? You can't inform somebody who doesn't want to be informed.
Thank you very much, Honorable Speaker, for giving me a chance to also make a comment. Honorable Speaker, I was not as excited as the Honorable Sankok and the Honorable Ndende, because I think as much as I'm not a lawyer, by sitting in this house, I've been able to understand processes, procedures, and products. And I believe that they should not be celebrating. For sure, 5 out of 7 is really wonderful. Honorable Speaker, kindly give me a chance to make a comment on your ruling, that it was a very, very good ruling, and that we have understood, and you have actually taken us through the process that the supplementary bill was taken through, and said that it was good, and you have identified the areas of weakness, and that you have given us a very good way forward, that in the future, the Cabinet Secretary, Treasury must adhere to timelines. And I think you have given us areas where there is lacuna in law, which needs to be handled. Honorable Speaker, what was shocking to me as the member for Kitui South was that people were really shouting loudly that it is more than 10%. It is only 7%. It was more than 10%, Honorable Speaker. That's what they kept saying. It's only 7%, Honorable Speaker. We would like to thank you so much. Continue guiding this House, and may God give you many more days so that you may continue giving guidance. Thank you, Honorable Speaker.
Member for Samburu County.
Asante sana Mheshimiwa Spika. Ningependa tu Mheshimiwa Spika kusema kile kazi lawyers wamefanya katika BBI. Ningeungana na wenzangu kusema sheria ya BBI na kile imeongelewa. Hakuna mtu anaweza kwenda kusema tumeshinda ama tumeshindwa. Isa lawyers wamefanya kazi yao, na maoni ni ya wananchi, na bado tunatarajia BBI itarudi na itakuwa tu sawa. Wenye wanataka kwenda kucherekea, waenda cherekea tu kama kawaida. Kwa sababu kawaida wanacherekea kitu aina mguu, aina mbele na nyuma. Kwa hivyo waenda cherekea hizo, lakini BBI bado iko kwa laini. Asante Mheshimiwa Speaker.
The member for Alego Usonga also wants to weigh in.
Thank you, Honorable Speaker. Honorable Speaker, I want to applaud your ruling. I want to applaud your ruling on the issues raised by Duale on the constitutionality of supplementary estimates. And Honorable Speaker, I want to say that after Baba has done his 10 years, you can take over. But what I wanted to say, Speaker, is that the issue of Article 223, which we all agree has been abused by Treasury in the past, where Treasury spends resources which actually should not be applied on 223, is something which this House must take note of. But more fundamentally, is that Treasury must abide by the constitutional regulations on when to notify Parliament on when they spend resources on Article 223. I think this is very substantial, and I want to urge the various departmental committees to ensure that Treasury does apply your ruling. Because, Honorable Speaker, there was a time the SRC Commission spent resources on Article 223, and when the matter was brought before a Committee of Finance and National Planning, we actually refused to approve. But, Honorable Speaker, they were not punished because Treasury refused to punish them. So I think what we need to do, Honorable Speaker, is that we must ensure that this House does apply the ruling which you have given. Secondly, Honorable Speaker, on BBI, Honorable Speaker, I want to echo the sentiments of my sister, Honorable Millie Odhiambo, that indeed we are very happy. And Baba has said that BBI will be back. Reggae will be back after Baba is sworn in as the fifth president of the Republic of Kenya. Thank you.
I think, honourable members, that should suffice, so that we can now go, because you can see many of you are walking out. They have forgotten about the issue of the supplementary. So, but anyway, honourable members, many of you, of course, would, I'm sure, would applaud the fact that it has now been settled. It is now tried law that what is contained in Article 255 with regard to which clauses may be amended in which way, and what is contained in 256 and 257 has been settled by the highest courts on the land, and that therefore the finding that the basic structure principle is not universally acceptable. It's only applied in a few jurisdictions. I think that is important. So, and indeed, that ruling agrees with some of the, if you recall, when members raised issues here, when that bill was here, our own ruling here with regard to the power of the House, the power of any member to move amendments. I mean, this has been restated, and I think it's good for the country. For me, I think that is important. And also the issue about immunity. The issue of immunity, I think, was, for me, those two issues were very crucial. The rest are the usual things that we can do, and the member for Suba North has said they can be dealt with at an appropriate time. That is important. Let's go to the next order, which is the business of the day, the critical business of the day.
Order number 11, the Supplementary Appropriation Bill, National Assembly Bill number 14 of 2022, second reading.
Chairman, Budget and Appropriations Committee.
Thank you, Honorable Speaker, and I would first start by thanking you for the ruling that you have given. Honorable Speaker, timely, Solomonic, and Honorable Speaker, is something that you have been grappling with. But as you know, Honorable Speaker, this is a House of Presidents and procedures. We found it happening. We tried to help the situation, but we are happy, Honorable Speaker, that you have been able to be firm. And I want to assure you, Honorable Speaker, because I believe that there will be other supplementary budgets that will be coming on our way. We will make sure that the rules and procedures are followed to the letter. Honorable Speaker, I want to inform the members here that last week we concluded the debate on this supplementary budget, and I would beg to move that the supplementary appropriations bill be read at the second time. As I move, Honorable Speaker, I want to say that the critical issues that are highlighted in this supplementary budget supplementary budget one, I want to bring to the attention of members that in this one we have put the 4.9 billion shillings that were in arrears, Honorable Speaker, for the CDF. We have made that funds available, and with the conclusion of this debate and maybe the assenting of this law, then definitely it will mean that those funds should be disbursed to the respective constituencies. I understand each constituency was supposed to get about 12 million shillings. Honorable Speaker, on a different issue, Honorable Speaker, the fuel crisis that has hit the world, Honorable Speaker, Kenya has not been spared. And Honorable Speaker, if you compare the fuel prices between Kenya and our neighboring countries, you'll find that our fuel prices are a bit lower, not just a bit lower. For example, in Uganda, most of the vehicles in Uganda are fueling in Kenya and going to Uganda. That one tells you that the fuel prices in Kenya are lower, far much lower than, that's true, and it's, Honorable Speaker, is good to confirm. I have already confirmed that in Uganda, per liter is about 160 Kenya shilling. In Kenya is about 130. And that is courtesy of the fuel stabilization, Honorable Speaker, which I from the calculations that we got last week, we are spending about 8 billion shillings, or even going to 10 billion shillings for fuel stabilization, Honorable Speaker. And these are some of the funds that we have also made sure that we allocated. Honorable Speaker, there is the issue of the pending bills. Pending bills has been a cancer in this country, which has brought so many companies, down. Companies that supplied government, companies that supplied government agencies, and they have not been paid. We have tried as much as possible to push for those payments. And Honorable Speaker, it's not good enough, but at least we have tried in this supplementary. Honorable Speaker, COVID is still with us. Many people maybe have forgotten that COVID is still with us. There are so many interventions that are being done to address the issue of COVID-related interventions. Honorable Speaker, in this supplementary budget, we will construct, or the government will construct, 50 new level 3 hospitals. Honorable Speaker, the 50 new level 3 hospitals will be constructed in each of the 47 counties. Honorable Speaker, this is after the very successful implementation of the same in our informal sector. Honorable Speaker, if you go to Kibra, if you go to Mukuru kwa Jenga, if you go to all the informal sectors here in Nairobi, you'll find a level 3 hospital. The patients who are going to Kenyatta, Honorable Speaker, are no longer going to Kenyatta. Kenyatta is no longer congested because the new hospitals, the level 3 hospitals that have been done in Nairobi through NMS have proved to offload the many patients that were going to Kenyatta. And the government has seen it fit to replicate the same in all the 47 counties and maybe 3 in some of the informal sectors. Honorable Speaker, I also want to inform this House that we have also put provision for alleviating the famine and hunger that is in the country, Honorable Speaker. There has been failed rains, Honorable Speaker, for the last, I think, almost 1 year, Honorable Speaker. We have put funds, or we are appropriating funds to make sure that we alleviate that situation. Honorable Speaker, this is just a repetition of what we actually discussed last week. And without saying so much, Honorable Speaker, I beg to move and request the Majority Whip, Honorable Wangwe, to second. I thank you, Honorable.
Honorable Wangwe. Thank you, Honorable Speaker. Honorable Speaker, I wish to second this motion that about the Supplementary Appropriation Bill, number 14 of 2022. Honorable Speaker, this bill is going to enable the heavy shocks that are existing, Honorable Speaker, in the country today. Most of us are experiencing constraint in terms of what we are able to consume because, Honorable Speaker, the production of the suppliers to the ministries have been curtailed, not to be paid, Honorable Speaker, because the money is not there. Therefore, Honorable Speaker, my urge to my colleagues this afternoon is that we pass this appropriation bill very fast so that the money trickles down quickly and we stabilize, Honorable Speaker, the challenges that are existing in the country. Honorable Speaker, those who are trading with the ministries and sagas, there is no money. And once there is no money in the central, in the government, Honorable Speaker, what it means is generally the private sector also doesn't have money at all. Therefore, it's important, Honorable Speaker, that we push this appropriation bill so that we get everything stabilized in the country. Good of what is being proposed in this supplementary, Honorable Speaker, generally is the 4.9 billion which is being going to the CDF. Honorable Speaker, we are towards the tail end of our term, and it's important that all the pledges made is achieved by all our colleagues. Notwithstanding, Honorable Speaker, those who will come back and those who will not. It's important that they fulfill what they pledge to their constituents, and it's good that that amount is put in the budget, Honorable Speaker. Honorable Speaker, I wouldn't want to take most of the time, as my chair has said, and I wish now to second. Thank you.
Member for Samburu North. It was not no, I was not giving you a chance to speak. You see, the member for Samburu North, I'm sure, where he was, he must have been conversing in the local lingua, so he didn't hear what was being. Honourable members, I propose the question which is that the Supplementary Appropriations Bill, National Assembly Bill number 14 of 2022, be now read a second time. What? Yeah? I'm told that here there is a proposal that I give two members. Very well. Where are the two? Here. You want to contribute? Honorable Shamala?
Thank you, Mr. Speaker, sir. Indeed, I have listened carefully to the chair of the Budget and Appropriation Committee, and I recognize and appreciate that pending bills must be settled. Pending bills are settled. It's important because you have money circulating within the economy. However, there is one thing that concerns me, and my heart was really aching when I heard Florence Mutua, the woman rep in Busia, discussing the issue of the slashing of funds for national schools on food, on the food and nutrition. And this really concerned me is because it is about children. Children need to be well nourished, they must be healthy, they must be developed in order to learn. I then saw in one of the expenditures or lines a recurrent expenditure bill for 500 million that fell under the National Land Commission. In fact, I even brought an amendment to the effect that this amount be, and in that amendment that this amount be removed and taken to the early learning and basic education program for feeding. It is on this premise and under access to information, because food is a human right, what was this recurrent expenditure to which was now reduced from 500 to 250 million, and why was it such a priority and a bigger priority than feeding the children of Kenya?
Member for Samburu North.
Thank you so much, Mr. Speaker. Mr. Speaker, I support this bill, appropriation bill, supplementary appropriation bill to be passed. But I want also, it is important to fast track it because, Mr. Speaker, from where I come from, we are facing serious drought. There is no water for our people. There's no food, and the government had stopped the supply of relief food because they say they want to pay cash transfer. Even that cash transfer is not available because registration has not been done. So this bill, I hope it is going along to fasten supply of cash instead of foodstuffs, and also to alleviate the hunger that is within our people. Parents also don't have school fees, and we are opening schools in the next 1 month. So I think, again, this money, if it is focused to pay money to the schools so that they can be able to get school fees for the children. Mr. Speaker, the other issue is about the equalization fund. For almost now 4 years, we have not been able to get the equalization fund, yet there are some projects which actually were awarded, and the work has not started because the contractors are not sure whether they are going to get money for the equalization fund. On the CDF issue, I want to thank the chairman and the committee for remembering the outstanding bills, the unpaid projects that were done by CDF committees in the previous years.
So this one again will assist in availing money to the local people so that the money can be circulate among the communities within our areas. The last issue, Mr. Speaker, is also about insecurity. That we are still facing a lot of problems. If you see in the media, we have been having problems in northern Kenya, especially where I come from, and also our neighbors, the Elgeyo Marakwet and Baringo. I think this money, if this supplementary budget, I hope it's going to support, and even Pokot. I hope this money which is released is going to help in beefing up security in those areas. Of course, we from that region, we still feel that government is not providing enough, especially in terms of policing. We still think that police are not able to contain in northern Kenya, especially in the Rift Valley areas of the valley, the Zukuta Valley and its environs. So we feel that as people who come from there, leaders, we feel that our local policemen, the local National Police Reserve, can actually become a backup to the police. And if they are recruited and vetted and trained and supported, empowered by some payment like what they have been doing before, this issue can also be addressed, the issue of insecurity. So I hope this supplementary budget will also have some, I see there's money for the interior. I hope that money will go along to assist in providing policing, supporting policing in that area, and also assisting Nyumba Kumi, and all the stakeholders that are assisting government to reduce insecurity. Otherwise, we need urgent address in the issue of supply of water and food for our people. Thank you, Mr. Speaker.
Well, there was an indication that, but I didn't get it, unless there was nobody on the left. No, I can see the member for Kwanzaa. It's only that he's raising his hand very half-heartedly. Are you sure, Honorable Kevin Wanyonyi?
Yes, I am. Mr. Speaker, thank you very much for the chance to contribute this supplementary appropriation bill. I think it's, as just mentioned by the chair, we have a serious problem of fuel in this country. And in fact, my coming to Nairobi from Western Kenya was an issue. I had to fuel my vehicle 3 times at a very high price. And I don't want to agree with the chairman saying that our prices of fuel is lower here than Uganda. You should ask me, because we having people going to Uganda to fuel. So I think you are actually out of the information, because the fuel in Uganda, Mr. Speaker, is even lower than this country. And I want to tell you, because I come from the border and I know what is happening. So it is good that you have put in some money there. It's good that you have done that, and I think it's quite good. The other thing is that, Mr. Speaker, it's a bit unfortunate that in this appropriation, we do not have money for the seeds and fertilizer for the farmers in the Western Kenya. And you see, we have been delayed. The rains have come in late, and I can tell you that we have a problem as far as farming is concerned, because the prices of fertilizer is very high. And I hope that in this bill, because I haven't seen it in details, there's some money for subsidy for the farmers, because the cost of fertilizer has gone up very, very high. And I think, Mr. Speaker, we should also look at that. And but all in all, I want to support this bill, and I hope we'll be able to trace some of the issues that are actually affecting our Kenyans. And particularly, as I said, the fertilizer issue and the fuel issue, which you has mentioned, CDF, I think you have also said, well, CDF, I think there's money for the projects that are not completed, and I think this supplementary appropriation bill has addressed that, and I hope that that will be able to help those who are actually depending on the completion of the projects in CDF will be completed in good time. As you know, the election is just around the corner. I support.
I think, you know, now members, I don't know whether it is, you see, we need many of you here. But you can see what is happening, everybody is just walking away. Let me hear the member for Odaya. Member for Odaya.
Thank you, Honorable Speaker. Honorable Speaker, I stand to support the bill, and more so, I support the critical areas that the bill has been able to address, particularly on NGCDF, the 4.9 billion, because this is the time we really need this kind of funds to support parents who are about to take kids back to school, and I'm sure our honorable members will appropriate enough money for bursaries, because we know that there are difficulties down there, that the cost of living for sure is high, and the only way to support our population is through interventions like bursaries and those other areas. Honorable Speaker, I also want to appreciate the inclusion of 400 million to pay pending bills, because this, Honorable Speaker, will go a long way in ensuring that there is money in circulation, and also support, Honorable Speaker, the contractors who are certainly suffering a lot when they are not paid on time. Honorable Speaker, I also want to applaud your Solomonic ruling on this issue of Section 223, because, Honorable Speaker, going forward, it is very important that that section is observed by Treasury in full, and it will go a long way in ensuring that we consider all matters during budgeting, because during budgeting is when we do the real planning, so that we don't leave a lot of projects and finance a lot of critical projects, Honorable Speaker, during planning, and then we do them haphazardly. Honorable Speaker, that ruling is very important, and I'm sure the way you have given, particularly the procedure of accommodating requests from Treasury, because for sure there was no procedure on ensuring that every request comes within the 2-month period to this House to approve. So, Honorable Speaker, I think we'll take advantage of your ruling today to ensure that this House, which is a budget-making House, is fully involved in all that goes on in the budget-making process. And it's a ruling that I'm sure that we need all to applaud. Honorable Speaker, I stand to support. Thank you.
Been public demand. The member for Kiharu.
Thank you very much, Mr. Speaker. I understand most of my colleagues contributed last week, Mr. Speaker, and I thank you for giving me this opportunity, because maybe I was attending to other issues last week. From the onset, Mr. Speaker, the supplementary budget or appropriation, Mr. Speaker, across the world should be for the unseen. But in Kenya, it has become perpetual, Mr. Speaker, that every time we read the main budget, there has to be a supplementary budget, Mr. Speaker, most of which, in its breadth, covers just the normal things, Mr. Speaker. And I think, Mr. Speaker, we should uphold, Mr. Speaker, what the supplementary appropriation across the world should cater for. That is for the unseen, Mr. Speaker, and something that could not be put in the main budget. But, Mr. Speaker, going through the many supplementary budgets that we have passed in this House in the recent past, there is always an increment of funds in the security sector, and even in the last 3 years, there has perpetually been increment of funds in the NMS. And Mr. Speaker, if you actually look at the main budget again, we have always increased our budgeting in these two main areas. And Mr. Speaker, the reason why I'm speaking about these two main areas is that in this particular time, we actually slashed some of the money that was meant for the school feeding program and increased the same money, Mr. Speaker, to the security docket. And even looking through what we are increasing, Mr. Speaker, we increased around 500 million shillings to Huduma Number, Mr. Speaker, a project that does not necessarily benefit the Kenyan people. Also, Mr. Speaker, it would have been my wish that we looked at our farmers, Mr. Speaker, in terms of lowering the prices of fertilizer, because, Mr. Speaker, as I said when I was moving my amendment to this supplementary budget, Mr. Speaker, we needed to lower the price of our inputs for agriculture and mainly the fertilizer. And, Mr. Speaker, we need to be seen as people who understand what Kenyans are going through. Mr. Speaker, coming here to increase money for Huduma Number, and at the same time you do not, Mr. Speaker, think about our farmers, and especially lowering the prices of fertilizer, I think is very insensitive. But also, Mr. Speaker, globally, I think as a country, we need to bite the bullet when it comes to the issue of pending bills. Mr. Speaker, it has become like a chorus, that every time we are talking about budget making process, every time the president is addressing the nation, we keep referencing on the issue of pending bills. But I don't think our words match our action, Mr. Speaker, because there are many vendors out there, there are many people who have done business with government who are wallowing in poverty, Mr. Speaker, after doing business with government, and they are all over chasing their payments. Mr. Speaker, we need to look at this issue of pending bill with finality, Mr. Speaker, and I wonder why we are introducing new projects, Mr. Speaker, which are not of emergency nature, and at the same time, there are so many people who have done business with government, Mr. Speaker, and who are owed colossal amounts of money by government. I think the issue of pending bills is very important, Mr. Speaker, in terms of the velocity of money, in terms of the circulation of money in our economy, because this, Mr. Speaker, in the long run, hurts our economy even at the bottom. Mr. Speaker, the issue of debt, and I keep talking about it here, is a very important issue when we are talking about budget making, and even as we talk about the supplementary. Because generally speaking, Mr. Speaker, our country, the amount of money we are using and you are appropriating to pay just interest rates in our loans has actually now exceeded the amount of money we pay for salaries for our civil servants. And, Mr. Speaker, we need to be very mindful as a House, as a nation, about the fiscal prudence in our nation. Because we have overborrowed, Mr. Speaker, and I have said before in this House that even after we input the cap of 9 trillion Kenya shillings, Mr. Speaker, if you tabulate the amount of money that has been borrowed by the Treasury directly and actually include the other monies, like the fallback position of the PPP and the guarantees, Mr. Speaker, we are exceeding 11.9 trillion Kenya shillings. And, Mr. Speaker, this is unsustainable in the long run because, as I said there before, Mr. Speaker, we cannot be a borrowing nation. And many people in this House, most of the time, they argue that most of the economies actually borrow. And most of us actually cite the USA and even Japan. But, Mr. Speaker, our conditions are different. In a country like Japan that has overborrowed, Mr. Speaker, even beyond 200% of their GDP, they also led to other countries. But, Mr. Speaker, our borrowing is one way. We only borrow, but we do not lend. Mr. Speaker, I think going forward, we need to be very mindful about the fiscal prudence in this nation. We borrow what is sustainable, and we should try to budget, Mr. Speaker, within the limits of our revenues. With that, Mr. Speaker, I submit.
Thank you, Honorable Speaker. Honorable Speaker, I'm understanding Order 95, that the mover be called to reply. I think we had agreed that 2 on that side and 2 on this side, and most of the contributors are in agreement with the supplementary budget so that we can go to the committee of the whole House and do the necessary tidings. So, Honorable Speaker, I ask that the mover be called to reply.
Before I put the question on 95, I want to go back to, again, because of certain businesses which are bearing between the two houses, go back to under number 6. Under number 6, to allow the chairman, Budget and Appropriations Committee, to give notice.
Thank you.
So that the business can be put on the order paper for Tuesday.
Honorable Speaker, thank you so much, Honorable Speaker. Honorable Speaker, I beg to give notice of the following motion. That is mediation committee, report on the mediation version of the county government grant bill, Senate bill number 35 of 2021.
The notice is that this House adopts the report, isn't it? Because now what you have said,
yes.
If somebody looked at the handstand, it will look like...
I want to take it.
Yes.
Thank you, Honorable Speaker. I beg to move that this House adopts the following motion.
In fact,
notice of the following motion.
Not moving. You're giving
the
notice.
Report. Yes, I'm giving. Thank you. Report on the mediated version of the county government's grant.
No, Honorable Kanini, please. Is it that it's not written? You know. But it is it's so simple that you wish to give notice of the following motion, that this House adopts the report of the, mediation, isn't it? Simple. It's so simple.
Honorable Speaker, today we are handling so many things. And
I know, but we don't want people to look at our records, the answer, and find something funny.
Thank you, Honorable Speaker, and thanks so much for your indulgence. Honorable Speaker, I beg to give notice on the following motion, that pursuant to the provisions of Article 113(2) of the Constitution and standing under 150, this House adopts the report of the Mediation Committee on the County Government Grant Bill, Senate number 35 of 2021, laid on the table of the House Thursday, March 31st, 2022, and approves the mediated version of the County Government Grants Bill, Senate number 35 of 2021. I thank you, Honorable Speaker, and sorry for the mix-up. Thank you.
Very well. We go back to the current motion. The member for Endebess rose in his place and claimed to move that the mover, understanding order number 95, that the mover be called upon to reply. I want to find out what is the mood of the House. It is never, that mood of the House is not found in Kitutu Church North. It is found in the chamber here. Therefore, I put the question, which is that the mover be called upon to reply. Will as many as of that opinion say aye? As many as the contrary opinion say nay? The ayes have it. As you can see, it is not in Kitutu Church North. Honorable Kanini Kega.
Thank you, Honorable Speaker. I want to thank each and everyone, Honorable Speaker, who has contributed, Honorable Speaker. And we have heard the concerns, Honorable Speaker. We will make sure that the concerns are addressed either in the supplementary tool or the estimates that we'll be considering in a few. Honorable Speaker, I also want to notify the House that there will be some few amendments that I will be moving in the first schedule, Honorable Speaker, as we go to the Committee of the Whole. I beg to reply.
Very well, honourable members, have been informed that we still have quorum. And thank you for staying this far. But just beg you that please continue, both in committee and for the third reading. Honourable members, I put the question, which is that the Supplementary Appropriation Bill, National Assembly Bill number 14 of 2022, be now read a second time. Will as many as of that opinion say aye? Aye. Will as many as the contrary opinion say nay? The ayes have it.
A bill for an act of parliament to authorize the issue of certain sums of money out of the consolidated fund and the application toward the service of the year ending on the 30th June 2022, and to appropriate those sums for certain public services and purposes.
The chairman, the Committee on Agriculture, you have an intervention before we move to the next order. Where is the chairman of Agriculture? He has placed an intervention. What? Member for Moiben. How? What?
Thank you. I was caught unaware. Thank you, Honorable Speaker. I have a request to make on the issues of the coffee amendments, which I think we signed yesterday and we were not ready, so we are requesting for deferring until next week, Your Honorable Speaker, sir.
You're not ready?
As in, we signed it yesterday, and I'm surprised that it's also on the order paper.
Very well. Very well. I think the member, the chairman, and contacted me earlier, before lunch, and indicated that they may be unable to move the amendments in committee of the whole House on this bill. But the Honorable Tiren, be ready then on Tuesday next week, because then it will, the bill must come. We need to clear many of these bills as possible so that they can go to the other House, so that we conclude the bicameral consideration of the bill. So, honourable members, when we go to order number 12, business appearing as Roman 2 is being deferred to Tuesday next week. It will not be considered in committee of the whole House, so that the committee will just consider what appears as Roman 1. Next order.
Order number 12, Committee of the Whole House.
Honorable members, order. We are now in committee of the whole to consider the supplementary appropriation bill, National Assembly Bill number 14 of 2022.
Clauses 2, 3, 4, and 5.
I propose the question that clauses 2, 3, 4, and 5 be part of the bill. There are no amendments to this. I therefore put the question that clauses 2, 3, 4, and 5 be part of the bill. Will as many of that opinion say aye? Will as many of the contrary opinion say nay? Ayes have it.
First schedule.
I propose the question that the first schedule be the first schedule of the bill. Chair, there is an amendment to this. Proceed.
Thank you, Honorable Chair. And from the onset, Honorable Chair, I would like to mention that under vote D1 on 1091-02-2000 road transport program, there is a proposed reduction of Kenya shilling 1 billion from the resources in the annuity program and an increase of the same to low volume CO and critical roads intervention. This was inadvertently left out as we were concluding the amendment to the motion on the report of the supplementary estimates. And it has nil effect because basically it's moving from within the same vote. Honorable Chair, I also beg to move other amendments. That is in respect of vote D1, D1091, that is State Department for Infrastructure, under program 020-2000, that road transport, by deleting the expression of Kenya shilling 3,438 million, and substituting therefore with the expression of Kenya shilling 3,138 million shillings. And the justification of is to cater for budget realignment on account of allocation that was wrongly added as we concluded the consideration of the supplementary estimates. I don't know whether I'll do all of them or I do one by one. Because it's basically the...
Yes, it is in the same schedule,
in the
so
schedule.
you can proceed with all of them.
B, in respect of vote D1109, that is Ministry of Water and Sanitation and Irrigation, under the program 117,000, that is Water and Sewerage Infrastructure Development, by deleting the expression of Kenya shilling 956,500,000 and substituting therefore with the expression of Kenya shilling 1,306,500,000, and the justification of is to cater for the realignment on the account of an allocation that was wrongly left out and included in the transport budget as we concluded the consideration of the supplementary estimate. You see that the figures that have moved from roads are the actual figures that came to water. We go to the next one. That is C. In respect of vote D1222, the State Department for Regional and Northern Corridor Development Infrastructure under program 101,330,000, integrated regional development program by deleting the expression of Kenya shilling 850 million and substituting therefore with an expression of 900 million. The purpose of this amendment, Honorable Chair, is to cater for the budgetary realignment on account of an allocation that was wrongly left out and included in the transport budget as we concluded the consideration of the supplementary estimate. D, Honorable Chair, in respect of vote R1214, the State Department of Youth Affairs and program as attached, that is youth empowerment, by deleting the expression Kenya shilling 29,628,874 and substituting therefore with the expression Kenya shilling 8,437,371. And the purpose is on account of the need to realign the vote head in the correct categorization from recurrent to development. Very straightforward. And F, in respect of vote D1214, the State Department for Youth Affairs under program attached, that is youth empowerment, by deleting the expression Kenya shilling 2,129,000 million. Sorry, let me take this once more. 2,129 billion 260. Sorry, 2 billion. You know, Honorable Chair, I'm used to the big figures. It's 2,129,268,901, and substituting therefore with the expression of Kenya shilling 2,167,335,146. And the justification is the amendment is on account of the need to realign the vote ahead in correcting the categorization from development to recurrent. I thank you, Honorable Chair. Those are the amendments. Thank you.
Honorable members, allow me then to propose the question that the first schedule be amended as proposed by the chair. I then put the question that the first schedule be amended as proposed by the chair. Will as many of that opinion say aye? Aye. Will as many of that contrary opinion say nay? The ayes have it. I now put the global question that the first schedule, as amended, be part of the bill. Will as many of that opinion say aye? Aye. Will as many of the contrary opinion say nay? The ayes have it.
Second schedule.
I propose the question that the second schedule be the second schedule of the bill. I now put the question that the second schedule be the second schedule of the bill. Will as many of that opinion say aye? Will as many as have a contrary opinion say nay? The ayes have it.
Title.
I propose the question that the title be the title of the bill. I now put the question that the title be the title of the bill. Will as many of that opinion say aye? Will as many of our current opinion say nay? The ayes have it.
Clause 1.
I propose the question that clause 1 be part of the bill. I now put the question that clause 1 be part of the bill. Will as many of that opinion say aye? Will as many of our current opinion say nay? The ayes have it. The mover to move reporting.
Honorable Speaker, Honorable Chair, I beg to move that the committee do report to the House its consideration of supplementary appropriations bill, National Assembly Bill number 14 of 2022, and its approval therefore with amendments.
I now put the question, which is that the committee do report to the House its consideration of the supplementary appropriation bill, National Assembly Bill number 14 of 2022, and its approval thereof with amendments. Will as many of that opinion say aye? Will as many as of our current opinion say nay? The ayes have it.
Honourable members, can we have the chairperson to report to the House?
Honorable Speaker, I beg to report that the Committee of the Whole House has considered the Supplementary Appropriation Bill, National Assembly Bill number 14 of 2022, and approved the same with amendments.
Very well. The mover of the bill to move agreement with the report.
Honorable Speaker, I beg to move that the House do agree with the committee in the said report, and I also request Honorable Kemunya to second the motion for agreement with the report of the Committee of the Whole House.
Honorable Kemunya for seconding.
Honorable Speaker, I beg to second.
Honorable members, I propose a question for adoption, which is that the House do agree with the committee in the said report. And with that, members, I move to put the question for adoption, which is that the House do agree with the committee in the said report. As many as of this opinion say aye, and as many as of a contrary opinion say nay. Honourable members, the ayes have it. The mover of the bill to move the third reading.
Thank you, Honorable Speaker. Honorable Speaker, I beg to move that the Supplementary Appropriation Bill, National Assembly Bill number 14 of 2022, be now read a third time. I also request Honorable Kemunya to second.
Honorable Kemunya to second.
Honorable Speaker, I beg to second and to thank the members for the effort they have put and for the time they have put in the processing of this and sacrifices made, despite the other onerous responsibilities that are calling for them out there, so that we can give Kenyans a break in terms of the financing of the activities. I beg to second.
Honourable members, I propose the question for the third reading, which is that the Supplementary Appropriation Bill, National Assembly Bill number 14 of 2022, be now read a third time. Let me just have a comment. Let me just request the Honourable. Let me hear the member. Just give the honorable member.
Three.
Yes.
Thank you, Honorable
Just for a
Speaker.
comment. Yes.
Honorable Speaker, I beg your indulgence and not be long, just to congratulate the chair of the Budget and Appropriations Committee and his chairman and his committee. I know, Honorable Speaker, the Honorable Mulele will just hold for a minute, I am sure of that. But Chair, I also wanted to point out, Honorable Chair, that indeed the communication that the Speaker gave is very well informed, but also to encourage the Budget and Appropriations Committee that where Treasury goes against the law, and we have a precedent, Honorable Speaker, in the Budget and Appropriations Committee of refusing to approve anything that goes ultra via the Constitution in terms of Article 223. You will remember this House, Honorable Speaker, declined to approve the Ruaraka land payment of 1.5 billion shillings, Honorable Speaker, and that is a record that is before this House. So I just want to encourage the Budget and Appropriations Committee, in future, anything that is ultra via the Constitution in terms of provisions of Article 223, this House has a mandate of denying that, and that matter then goes to the Public Accounts Committee, and it's my hope that even on the Ruaraka land scandal, Honorable Speaker, that the Public Accounts Committee and other investigative agencies will be able to get to the root cause, because this House did disapprove that payment of 1.5 billion shillings, and therefore the Ruaraka land thief and those who are collaborators, Honorable Speaker, can have action taken against them. With that, Honorable Speaker, I support.
Very well. The mood is I put the question, honorable members. I move to put the question for the third reading, and I've confirmed that the House is properly constituted for me to be able to do the same. I therefore put the question, which is that the Supplementary Appropriation Bill, National Assembly Bill number 14 of 2022, be now read a third time. As many as have that opinion say aye. And as many as have a contrary opinion say nay. The ayes have it.
A bill for an act of parliament to authorize the issue of certain sums of money out of the consolidated fund and the application towards the service of the year ending on 30th June 2022, and to appropriate those sums for certain public services and purposes. Order number 13, the Elections Amendment Bill, National Assembly Bill number 3 of 2022, second reading.
Order number 13, honorable members, this is a resumption of debate interrupted on the Wednesday, March 30th, 2022, the afternoon sitting. And on a request list, we have the member, hoping that he never spoke to this, let me confirm. The member for Navakol. Very well. I have confirmed that the leader of majority was moving. So you have the floor to. So you have the floor, the leader of majority.
Honorable Speaker, I think I had started the moving of this bill and had identified the four key objectives of this bill. And I don't need to repeat them. And I was actually looking at the third objective, which is the extent to which this bill seeks to align with the court judgments that have arisen, especially following the challenges of the previous elections. And I did indicate, and to just get my flow back, that as a result of the judgment in the Katiba Institute decision, the court declared the provisions of section 39(1)(c) A of it, 1D, 1E, and 1F, as well as 1G, invalid for purposes of being unconstitutional. And I did indicate yesterday that the risk we obviously have is that these are still showing as if they are part of the bill. For anyone downloading the bill, the Election Act, number 24 of 2011, it still contains these provisions, and until Parliament pronounces itself and says this should be deleted from the law books, they will still remain there. So they are otious, they are redundant, but they are still lying there, and this bill is seeking to actually expand them from the law books to the extent that the courts have declared them unconstitutional. In terms of 39(1)(c) A, I think the court was unhappy with obviously the way it's worded, and it caused the problems and the challenges that came. And what the consultation between the Attorney General's office, between the IEBC as the primary stakeholder in this matter, have now come up with a new formulation, which is basically to replace the entire 39(1)(c) and replace it with a more systematic formulation that starts from the polling station, because the courts did underscore the primacy of Form 34A and Form 34B as, especially the 34A, that the results declared at the polling station, I think that's the minor KI decision, that is the result. And hence, the bill then seeks to capture the flow of results once they're being announced at the polling center, that the presiding officer would electronically transmit that image directly to the National Tallying Center, and then will also manually transmit the same to the constituency tallying center, and the constituency returning officer is then required to collect for the constituency, declare the winner for the constituency, and then also take physically the collected results to the National Tallying Center, which is basically an arithmetic exercise. And then the commission, basically their job is to tally, verify, and declare the results of the presidential election for the national, for the polling center station results. You will note that in the existing 1C, there's a third provision in the current act, which basically requires the IEBC to publish the polling result forms on an online public portal maintained by the Commission. And I believe this is part of the challenges that we are witnessed, and to avoid those things. So that has been removed, so that we now let IEBC do what they have to do within the Constitution and announce the results in accordance with the Constitution, without having to this issue of provisional results, which have been one of the things that have raised emotions unnecessarily, as people get into that portal and pick what they want to see. Some media hype up what they want to see, and it's in this kind of situation of hyping up that and hyping up the results that has caused unnecessary tension in the people, so that when results move in a direction that people do not want, the standard thing with the Kenyan people is that the election has been rigged. So we would want to let that happen, just as it happens in the constituency, that all the results come, they are tallied. There's no reason why people cannot do their own tallying individually from their agents, but then we don't have this overhyped. And I believe that's exactly why the court also removed this live transmission by the media, which was causing unnecessary tension. And we saw that happened in 2007. We saw the challenges had in 2017 without the standards being put. Especially noting that we also have close to 11,000, according to IEBC, polling centers that do not have the 3G coverage to facilitate that electronic. So while waiting for those results to come and creating some hype differently, then that could cause problems. I also And I think this, apart from the Katiba, it also brings in the 2017 election petition in the court, where the court decreed that the final election results is what is contained in the election declaration forms, which is the primary document, and I think I've explained that. Further, the court took issue with some of the amendments then, which had been introduced in 2016. And these are the ones that were declared unconstitutional, that had eliminated the term prescribed form. So now we are reinstating that form, that it's in the prescribed form, not just any form. So the main issue really that the court had warranted a declaration of invalidity of Section 39 was failure to indicate that the results submitted to have to be submitted in the prescribed form, which is the famous Form 34A series at the polling station, Form 34B at the Constituent Standing Center, and I believe it's Form 34C at the county. So that 34 series is important, but it must be in the prescribed form, not just results being transmitted. That's what the court told us. So basically, to quote, if you allow me, Honorable Speaker, to quote part of that decision in the court, the judge observed that the problem, and I quote, "The problem insofar as I can see is with regard to transmission of results from polling stations to the constituency and national tallying centers as required by the new section 39(1)(ca). And that 39(1)(ca), again for the record and for members, basically says that for purposes of a presidential election, the commission shall electronically transmit and physically deliver the tabulated results of an election for the president from a polling station to the constituency tallying center and to the national tallying center. Now, so what the judge observed then, if I continue, is first, there's no requirement for the results to be transmitted in any prescribed form, which was an essential requirement in the deleted subsection. This was also an essential safeguard that guaranteed verifiability, transparency, and accountability of the election results transmitted from polling centers to the constituency and national tallying centers. This is made even more troubling by the fact that results will also be physically delivered to the constituency and national tallying centers, but in no particular prescribed form. This not only opens the results to possible adulteration and manipulation, but also mischief. The amendment obviously reverses the gains the country had made in electoral reforms, including results transmitted in a particular form. Honorable Speaker, at the very core, this bill now tries to streamline and accord regard to the decision of the courts in both the 2017 court challenge as well as the Katiba Institute decision of 2018. Furthermore, I'm also reliably advised that the committee may be making some amendments to this to make it even more elaborate to avoid any doubt. And I'm sure we will, by the time we come to the committee of the whole House, we will have the benefit of what the bill proposes, what the committee is fine-tuning it into, so that we avoid having to go against the decision or having to have an election nullified on a matter of process or just the amendments coming from this House. The other bit I did mention is that the bill has mandated the Commission to ensure the establishment of a complementary mechanism for transmission of results, and I'm reliably informed that the regulations are currently being worked on and should be in the House for consideration within the time, certainly before the House breaks. Again, like I said, this is really the crux of the matter. I know there is also an issue that members have raised on some amendment to Section 27 of the Act, which is basically looking at closing some window or harmonizing. And I think this is clause 16. I just want to highlight that currently the independent candidates, as per the Constitution, are required to be out of parties by 90 days before the election. The people who are sponsored by parties, their registers are given 120 days before. Then you have nominations, I believe, for this particular year. The schedule is that they should have been cleared by 22nd. So between the 22nd of April, when the results of the political parties' candidates are finalized, and the 9th of May, there's an open window of like 14 days when people could well move from political parties to independent. And it did seem unfair that, first of all, people are almost stopped from moving from one political party to another after the nomination, but you can become an independent. And also for people who really put lots of effort into the election, and the people who you beat in the nomination then come back to challenge you again as independent. It doesn't look fair, and I think that's why the IBC, as part of tidying up, did request that perhaps we need to synchronize those two dates so that what's good for the goose is not good for the gander. If you choose to be independent, choose to be independent ab initio. If you choose to be a party sponsored candidate, do so at the beginning. And those two processes should take place simultaneously within May, rather than now what we are doing within April, and others then have advantage of having to do it in May when they've also got the advantage of the ground and what is happening. And yet it doesn't look like fair play or fair ground. So there's an amendment then in section clause 16, which hopes to tidy that realistically, and I think that's what we need to think ourselves. Realistically, because of we had delays, obviously, in the publication, in processing of the bill, by the time we pass this through Senate, I'm sure the nominations will have taken place. So this clause may not work for 2022 elections. And I want the House to have that in mind, that when we are doing it for posterity. And if we believe that that's the future of the election, that's how it should be, then we should not limit ourselves who are here and say it will affect us. It won't. It will not, because we are already on fast tomorrow, and by the time we have, some parties have already done their nominations, others are doing from next week. Completion will be by 22nd, and certainly this will not affect because parties have already done, and IBC is not going to revise its schedule for nominations because of this to take it to May. So this is for 2027 election in all probability. The other, I think the other item, I don't need to go through the others, because that was a fundamental thing that I just wanted to highlight to this House, so that as we make decisions, we make with a full disclosure. And again, it's open for debate. Members are at liberty to express themselves on what they feel about that, but most particularly noting that it's futuristic rather than for now. But I think the rest is, like I had indicated yesterday, it's a very simple bill, it's very straightforward, and I look forward to support of the members. We are already late in the processing of this bill, if you ask, because it will be good that by the time people are going for elections to actually know the operating law that they are, that's guiding those elections. And like I also said, a number of the clauses here is more of nomenclature. It's about sorting out between what is a nomination, which is really within the realm of the political party's registrar, and what is the registry of candidates, which is within IBC, which terms are now being confused because they are contained, and people keep talking on nominations. But we are now clarifying all those. And the other one, political party, again, defining it within here to be in accord with what is defined in the Political Parties Act, just again, for avoidance of doubt. And the last one is just also to recognize now, especially now, I'm very happy when we were doing the Political Parties Act, we had opposition because people thought that we were actually creating a coalition for one side of the House. In the event, we now have two coalitions running. I think we have the Azimio coalition on one hand, and we have another one, Kenya Kwanza Alliance, on the other side. So the law we did has actually helped both sides of the divide to move forward. But for them to actually actualize the benefits of the moving forward, we now need one final step, which is to allow or facilitate how either of these two alliances plus several others that also form will then submit their nomination rules, and which is not provided for in law as of now, and is being provided for in this new act. Honorable Speaker, I'm passionate about this thing. I'm very happy that the committee of JLAC has been looking at this bill, even when it was a legislative proposal. They had a lot of time with the IABC, and they discussed it, and even by the time it came for publication, I'm sure they had already agreed on most of the issues. And on that note, Honorable Speaker, I beg to move and request the Honorable T.J. Kojwang, the Vice Chair of the Justice and Legal Affairs Committee, to second.
Very well. Before the Honorable T.J. Kojwang seconds, please remember, join me in welcoming two students from Kikuyu constituency who are seated at the Speaker's Gallery. Angela Wamunyu from Kianda School and Hemi Mumbi from Miara School. You're welcome to the assembly. Then, yes, can we have Honorable T.J. Kojwang?
Madam Speaker, I thank you for an opportunity to second this bill. May I know that I have 30 minutes? I think that is what available for me so that I can plan myself accordingly. Madam Speaker, this bill is a culmination of several bills that...
Honorable T.J., yes, you have 30 minutes, yes, because you are doing it as a chair.
Yes, it is a culmination of several legislations we have made to safeguard the electoral process. You know that we worked on Political Parties Act. We have worked on several bills touching on campaign financing. This is now the last of them that therefore anchors the electoral process in Kenya. It is an important bill for members. We decree, everybody has said so, that election legislation should not come in the middle of election cycle. It is not wise, but here it is, as we can see. The problem of legislation making is that government bills would emanate from cabinet through the Attorney General. This is where there's a disconnect, that we need to see how to process these things in a manner that gives the House the teeth that it has for legislative making. And so they take as long as they want in cabinet, and they bring to us these things at the tail end of an exercise. And so doing the best we could with what we have, we still have a situation like such as this, that while a referee has already held the whistle and the players are on the field, then the referee holds the game and changes or seeks to change the rules. It is not fair. And we have said so. We have told the Commission, we have told the Executive that in future, this House will express itself very strongly on such processes that seem to be changing rules of the game, as it were. It is because of this that, for example, Madam Chair, you see members are reacting naturally, because it is coming at a point at which people have taken interests, and there is the fear of the unknown. Not actually fear, but it's the anxiety and the perplexity of the unknown. And so when you find changes in the middle of the ship, it is a problem. But having said so, I want to assure the country, and I want to assure members that we as a committee, we have looked at this bill in and out, and the text that the committee has come up with is so far the cleanest and the safest that there has been in the history of electoral practices in Kenya. The bill, as you see it, is very raw, but it gives the skeleton, the structure of the amendments that are necessary to keep it strong. But I want to urge members that before you look at the bill and make an opinion, please look at the report of the committee, which is available even on the portal. Even the country, members of the public, can approach and can get the portal and read the committee's views. In it, there is a proposal, legislative proposals that are going to amend what you find in the bill. When you consider those closely, and when you put together with the parent act, and when you look at what the bill is suggesting, you will be persuaded, no doubt, that this is the clearest text that we could have to progress the process of our electoral system. There are only three, let me say 4 objectives in this bill, which has been adverted to very well by Honorable Kimunya. And I like Honorable Kimunya has done a lot of full disclosure. Everything that needs to be said, he has said the way it is in the bill. But let me just summarize them in 4 subsets. Number 1 is to do with transmission of results. As you know, that transmission of results under Section 39 was declared, many of the provisions under that section was declared unconstitutional by the courts. And so, as it were right now, were we to proceed with this parent act the way it is, there will be no legal framework that would control transmission of results. What has been declared void is void. It is not there anymore. In other words, there is no legislative framework. There is the Constitution, but there must be a legislation that operationalizes that Constitution. So you go into an election which cannot be transmitted. What you have will not be an election, it will be shambolic, it would lead to serious chaos, it would be a big problem that would affect the national security of this country. So it is very important. I heard some members say yesterday that, you know, we can just go to elections even with the parent act the way it is. I dare say that if we go into an election without these amendments, and I'm sure members of the Senate are listening, it is important to them. We cannot withhold these amendments. We need to process them so that we have a credible, verifiable, mature an election that can measure up to the Constitution. Number 2 is something we call the process by which we do data processing. You see, Kenya has Turkana, Kenya also has Wajir, Kenya has Ruaraka, and all sorts of places in this country. Young people will tell you that there is something called 5 GB, there is something called 4 GB, there is Turaya, there is all this technology that has come. You have seen in petitions one after the other, including the presidential elections that we have. They are in some parts of this country in which you are unable to get those technology. And an election officer has to travel 300 kilometers looking for that network, getting under a tree or getting into a spot in which he can be able to transmit. Now, that has to be regulated. It is called, we called it in the other amendment, a complementary mechanism. if you don't have a complementary mechanism, you leave IEBC to do whatever they wish to do with the results. You will find a returning officer who is unable to transmit the results, and so takes 5 days in his house with the results and walks to Lokinyang and tries to find how to travel to Nairobi because there is no regulation to it. So the second thing that these amendments deal with is the complementary mechanism of transfer of that information. And we have said that since it is something which is case by case, since it is something which is detailed, IBC must give us regulations which tells us exactly how this Thuraya will be used, exactly how 4 or 5 GB will be used, if network or somebody switches off the light at night, what really must be done. And we have said in this bill that we must see these regulations in this House 30 days from assent of this bill, meaning that by May, they will have to give us these regulations, and we'd have to scrutinize them to know that they fit the bill. The third thing is we have had to crystallize the court cases that have come about. You remember the Supreme Court, the Raila 1 and the Raila 2. You remember the second presidential vote. You remember several cases that have happened, starting from the Katiba that the leader of majority has talked about, to the others that emanate from the Supreme Court decision. Now, and this is how democracy works. We make the law, but somebody else interprets the law, and somebody enforces the law. And so when we did our best as at that time, the courts have scrutinized some of those specific provisions and have found them unconstitutional, void, or those which they cannot be operated. Now, if you don't work on them, then you have a vacuum. And you cannot allow law to operate in a vacuum. Law must be there. Now, members need to know that we are Amurabi, the lawgiver. We cannot shy away. We must give the law. If the court says this is unconstitutional, then we must address that situation and say what the law must be. And so we have summarized all those kind of cases and identified which of those have been affected and in what manner they can be rectified. Now, those are not idle issues. Those are important issues, so that I would just want to underpin the importance of this legislation and how it will affect the elections that will come. But specifically, we have interacted with this bill when it was a legislative proposal. That is before even the leader of majority conceived it to be a bill. And Ada was telling him the other day that we have engaged on this for more than 8 months. He didn't believe me because, he was shown these proposals much later. But because of that, we have really some background. We have also interacted with the stakeholders. This is the bill that has gone through very serious public participation from the finest legal minds you can find in this country. And so I just want to assuage members who think that there is, or who may feel that there is something which they have not, something that they don't know in this bill. It has received what human beings can do has been done in this bill, and it is safe. Now, in the first page, we noted that raw as the bill was, we needed to make it in such a manner that it can be consumed. And so small things like having a valid Kenyan passport. You may wonder, why are they saying valid Kenyan? I mean, a passport is a passport. It must be valid. There is nothing called a valid. An expired passport is not a passport. But for abundance of caution, because that is what Kenyans are understanding. especially diaspora. You go there, you've been in America for 10 or those donkey years, and of course you don't have a passport. You have what is called an expired passport. But because it is your democratic right, you go to LA, Los Angeles, and you say that you must vote. And you produce your passport and say, this is my passport. But look, it is not a passport. It is an unexpired document. So for abundance of caution, we have added the word valid so that the owner knows that it is his duty to renew that passport. By the time you take, you are identified, and by the time you are voting, that passport must be valid. There are, of course, issues of nomenclature in clause number 3 that we have had to deal with to clear up the text. But you see, clause number 3 deals with the situation of Mariga in Kibra. You know, somebody knows that there is a by-election, and by-election he cannot register in that constituency, so he runs to Ruaraka and gets registered, and because now he is a registered voter, he comes to Kibra and he says he must vote. Yes. Yes, clause 5. That is clause 5, yes. And so this is what we are saying, that we have to find a solution. And we read the law correctly, I think, in section 5 of the Parent Act. In fact, Mariga should have not happened. If you look at clause 5, section 5 of the Parent Act, immediately there is a by-election, registration ceases in the whole country. By the way, it surprised me. In the whole country, just because of one by-election, there should be no registration during that by-election. And so Mariga should have not been allowed to have registered himself, even wherever he went, to be able to go to Kibra. But at that time, it may have been an oversight on the part of IBC to have allowed Mariga to have registered. But again, that begs the question, why would a by-election in Kipipiri be a hindrance to people in Kibra to continue registering? Because that by-election is only affecting one electoral area. So we have crafted a legislation which therefore only ties it to Kipipiri, only the people in Kipipiri. And if you are going to vie in Kipipiri, in that affected area, you must have registered inside there to be able to participate, so that the Mariga issue will be solved. If you look at clause 4, we are trying to create an empirical distinction, normative distinction between what is inspection and rectification. You know that inspection is a process that goes throughout, and that is how it should be. But rectification, just a few days to, or a couple of days to the election, a voter should have the right to go and inspect the register and say, hey, my name has been misspelled, or the area in which I am supposed to be voting is not been captured correctly. So that there is a difference between inspection and rectification. Over the page, if you consider clause 5, no, I think this, yes. I think this is clause 5, you are deleting clause 5. And I want us to talk about this, leader of majority, with a lot of fairness. I am the one who understands the question of mass voter registration, mass voter movement, because this is an urban problem. You go to Ruaraka, somebody decides, and KJ will tell you there, somebody decides that because this is an urban area which is just next to the other, because KJ has been blessed, as he is usually blessed, with a little bunny in his pocket, all members from Ruaraka want to troop to his constituency just to benefit from the little that he has. As soon as that process is done, they are running again to this other side because, looking for CDF and looking for an opportunity for KJ to sign something or the other. Now, this is a worrying trend in Kenya, so that then you find that, as leader of majority was saying, decisions which are made in that constituency is not made by the people who live, or who have interest there. Fair enough, Leader of Majority, we agree. But my concerns of the Constitution is supreme than all these other issues that I see. I want to understand what is the text. So what is the policy decision IBC is bringing? I can see the mischief very correctly. But how do they want to approach it? So you see, in the bill that we have, they are saying that you should be ordinarily a resident, you should be carrying on business, you should be employed, or you should possess land or residential building. Surely, this is, if you come to Ruaraka, you are literally abusing people of Ruaraka. How do you expect somebody in those beautiful cartons that we have as houses to start saying that I have to be employed? Who is employed in Ruaraka? And who is responsible for unemployment in Ruaraka? Then you say I should have possessed land. Which land should I possess in Ruaraka? And who should be responsible? He says that we should have a tenant. Yes, you can add. But you see, Honorable Leader of Majority, he lives in Karen. And if he doesn't live in Karen, maybe he lives in Upper Muthaiga, where then there is a beautiful lease drawn by fabulous lawyers, which can show that he's a tenant. Now, how am I supposed to show that I'm a tenant in those carton houses? This is an affront to Kenyans. And until Article 43, and until those social rights, the country must work towards uplifting the majority of Kenyans to such a level that you can now ask some of these questions. And why would you want to make the voter have the burden of proving himself anyway to enjoy his rights? Now, what IBC are doing, they're asking people for letters from the chief. Now, which chief would show that I'm a resident? It has been abused. You have to pay chiefs money to be able to give you a small 100 bob, to be able to give you a letter. So we said that whereas we see the mischief, the manner in which you have told us under Article 38, subarticle 3, is not reasonable for the enjoyment of those political rights. And in any case, even then, these are rights which can be limited, all right, but you know that you have under Article 24, Article 2, you have to show how that limitation is going to work, the extent of that limit, and exactly what you are limiting. And so we write the law, but the policy makers is the primary people who are IBC. So let them produce a policy which works around this subject, and when that is done, we will accept. For example, probably they may think of more innovative approaches like creating some discretion on the returning officer to ask one or two questions that would then show what this person is. Another one is to create an offense for these people who are paying people to move from one constituency to the other. And so when the time will come, we will put a member for Suba North. This is very clear. We are going to propose legislation, amendments, that this is really unconstitutional. And that is the view that we took, both in Clause 13 and Clause 14, tries to say that the voter must be a voter at the time. This is for a vacancy. If, for example, somebody leaves the assembly either by death or resignation, then the law would have said that somebody must have been a voter in that electoral unit. Now, we think that that is adding a restriction that the Constitution did not envisage, because Section 25 of the Act deals with what is the qualification and disqualification, so that this is over and above what the law says. Clause 15 and 16 have been spent. If you look at the Political Parties Act, you will see that we took them over in the consequential amendments. So they have been spent. That is why we are preferring to delete them. But something that is very close in the heart of member for Suba North, and this is the sweetener. I really wish that all members would see this. Member for the Dagoretti South, we are not going to restrict anybody in the view of the committee for movement, either because you have finished just with the parties to be independent. Honorable Kemenya has admitted that this really will be something that will affect the 2027. But let's be fair. Let us work as government. Let executive work. Let legislature work towards attaining some political stability in the political parties. Nobody, I mean, everybody knows that political parties have not been developed to the sense that they have organs which can really do those things that the Constitution requires them to do, whichever constellation you are thinking about. And so let us work on non-legislative interventions. Not everything should be legislated. Should we legislate how parties, for example, we give more money for education, voter education, civic education, giving parties to insist on creating structures. Those are things which are non-legislative interventions that then we can reach to a level we say, okay, these political parties, now if you want to choose to be dependent, you decide from day one and you are independent. Like in Germany, they have members of the Green Tea, and they are there, even if they are so few, like 12, but they are there. In fact, right now, they are in the ruling coalition because of their steadiness in democracy. So we are not just going to leave it for 2027. The sweetness is that we have decided as a committee to delete it. We will persuade the leader of majority that let this sweetener be here so that at least we are assuaged that things can still work, especially member for Suba North. I am sure she's not going to stand as an independent, but she must be vigilant to create some space for herself. There is no politician who wants to close himself. Unless you want to be, which cat would want to have a house without a window? I mean, we will just be less than wise if we were to do anything like that. So, member for Suba North, I know you have a direct ticket in your hand somewhere in your purse. But if something happens, because something can happen, you still have a period, some 13 days, by which you can still be an independent candidate. Now, there is the new clause, but that is not so serious. I think what is serious is clause 20, dealing with section 39 of the Parent Act. This is what I think I may want to spend a few more minutes. The leader of majority has explained very well. You see, when you look at a case, there is what is obiter dicta, and there's what is called raison d'etat. So that people have been saying this section is unconstitutional, this is void. But we went into those cases and read them page after page, as you have read them ably there, to know what was in the mind of the judge. What did the judge find offensive? And so we went in all these sections, and we found that really the problem with electronic transmission was not the fact that it was not clear. The problem was that the judge found that there is a piece of legislation which is saying that they will be transmitted, but it does not say what will be transmitted. Then it says a returning officer will go there physically. So he says, how do you have thousands of people trooping in the national tally with nothing, and they claim to be transmitting things? So he says there is an essential ingredient which is called, I think you'll have to give me time. We have been here since, yeah, but I'm summarizing. I'll be there. Prescribed form. That was the word which that legislation missed. So the moment we fixed prescribed form, it was sorted. Now, the last thing is we need to talk about complementary mechanism, leader of majority. And we have said that we need to see regulations approved by the House. In fact, we have done it in a text so that it is not going to go to delegated legislation. We are going to scrutinize it here in the plenary. And when we are thorough with it, then we will allow it. I know that Section 83 was a problem. And so that we don't so that we can avoid the problem that we had with Section 83, we have decided to let it go and let the Constitution speak for itself and let the law speak for itself. The last one has to do with dispute settlement. I've just received a text here from IEBC, which is persuading me that I need to rework the content of Clause 22 so that IEBC has a jurisdiction of dispute settlement, and that dispute settlement should be in 72 hours from the date of from the final date of registration of candidates. So, Madam Speaker, the timing is still 72, but they are saying that, look, it must be after the registration of all candidates, because if you don't do that, the question will be, if you let them publish, then it will be final. The question will be, now what are...
Let me add him 2 minutes for him to be able to summarize.
So the question would be, what are you going to dispute over when a gazette notice has gone and which is final? So they are like urging us to say that we will have 72 hours from the date of, from the time of registration of all the aspirants. Yes, of course, yes, instead of the 48 provided. So, Madam Speaker, this legislation is safe. In any case, this is second reading. Let us debate it with robustness that we can. But let us all come for committee stage. And I want to urge members to proffer as many of their proposed amendments as they can. With the leadership of the leader of majority, we can still come and sit down and harmonize all those viewpoints and come up with a legislation that will pass with the Senate without mediation. Because again, that is where the problem is. It could be held there for a long time, and yet this process must go on. I want to thank you for that opportunity to second this bill, and Leader of Majority, we want to thank you for the services of your office in the committee. You provided for us a very competent legal young man. I've never seen, I did not know that there are so many young men in this campus that are so sharp. Thank you so much, and from the office of Madam Speaker, you provided for us the staff and the clerk which helped us work on this legislation. I thank you, and may God bless you.
Very well. I second. Yes, you want to be on record second?
Yes.
Just give me
I therefore hereby second. Thank you very much.
Thank you. Honourable members, I therefore propose the question, which is that the Elections Amendment Bill, National Assembly Bill number 3 of 2022, be now read a second time. Yes, the Honourable Member for Dagoret South, Honourable Waweru Kiari, your intervention, a point about.
Thank you very much, Madam Speaker. And this afternoon, there are two main reasons why we were coming to the House, because there were two very critical businesses on the order paper. And one of them is this one, Madam Speaker, where we are going to do fundamental changes to an election law that is going to actually affect even members of this assembly and the country, Madam Speaker. And looking around the House, Madam Speaker, I'm told that the Speaker is blind, and so I'm calling your attention, Madam Speaker, to the quorum in this House, Madam Speaker, being that the people in this House, you can actually even count them in one hand, Madam Speaker. So, Madam Speaker, a matter of such importance, national importance, Madam Speaker, it would be sacrilegious. So, Madam Speaker, the best we can do with your direction, Madam Speaker, is to bring to the attention of members who are within the precincts of the parliament that we actually don't have quorum in the chamber, and we can actually ring the quorum bell for 10 minutes, Madam Speaker, failure to which, Madam Speaker, it would be actually sacrilegious for us to process this bill in a house where we have 4 members sitting, Madam Speaker, and pass it. Thank you very much, Madam Speaker. I'm calling your attention to the quorum situation in the House. Thank you very much, Madam Speaker.
Very well. Honorable members, the Honorable Kiarie has stood on standing order to call for the attention for quorum. And from where I sit, I confirm the House is not properly constituted, and so I do order for the quorum bell to be rung for 10 minutes.
Yes. Well, the third chairperson of the Speaker's panel, Honorable Jessica Mbalu, has just ordered that the quorum bell be rung for 10 minutes to allow members to get back into the chambers. This is after Dagoretti South Member of Parliament, Honorable John Kiarie, raised the issue on the quorum, telling the chairperson that there is no enough quorum to debate the current bill that is on the floor of the House. Currently, what the members were looking at was the Elections Amendment Bill. The Elections Amendment Bill, National Assembly Bill number 3 of 2022, tabled by the leader of a majority party, Honorable Amos Kimunya. It is a bill that is on the second stage. And this particular debate was a resumption of a debate that was interrupted on the Wednesday of March, that is 30th, 2022, in the afternoon sitting. So this afternoon, members were also expected to debate on this particular bill to give out their opinions on where they believe needs to be changed or amended. And basically what is happening is that there is no enough quorum, an issue that has been raised by Dagoretti South Member of Parliament, Honorable John Kiarie. This particular bill seeks to amend the Elections Act 2011. It has 23 clauses to it. Clause 2 of this particular bill seeks to amend Section 2 of the Act in order to provide for a clearer definition of nomination and political party. The bill also deletes the definition of nomination day in the Act, and the bill also seeks to define the term registration of candidates in relation to selection and election of party candidates to cater for the inclusion of new provisions on conduct of party nominations, which are to be introduced into the Act. Already, members have started debating on this particular bill, but because it is a bill that is a critical bill, especially now that the country is headed for the general elections, members say that the House requires the requisite numbers for this particular bill to be debated to the fullest, or for members to be able to participate enough and air their opinions and views on this particular bill. So what is happening currently is that it's a quorum bell, 10 minutes, ordered by the third chairperson of the Speaker's panel, Honorable Jessica Mbalu, to allow members to get back into the chambers to debate on this bill. Clause 3 of this bill seeks to amend Section 5 of the Act to provide that a person must present a valid Kenyan passport during registration as a voter. that a person must present a valid Kenyan passport during registration as a voter. Clause 5 seeks to amend Section 7 of the Act to provide for qualifications for transfer of registration. This is an issue that on the 30th of March 2022 in the afternoon sitting was expounded by the Majority Leader Honorable Amos Kimunya regarding the provision of qualifications for transfer of registration. Clause 6 seeks to amend Section 8A of the Act. This one relates to the audit of the Register of Voters by deleting subsection 3 as it makes reference to the first general election. Members are expected to get back to the chambers as ordered by Honorable Jessica Mbalu for this, or rather for the debate on this particular bill to continue. This is after one of the legislators, Honorable John Kerie, rose before the floor of the House to indicate that the House lacks a requisite quorum for this crucial bill. This is the Elections Amendment Bill, National Assembly Bill number 3 of 2022, which is on the second stage, and members are currently debating on this bill. It is a crucial bill, especially at this moment that the country is gearing towards the election period. And there are amendments and proposals in this particular bill that, according to the legislators, the House requires enough numbers to be able to continue with the debate on this bill. The bill has 23 clauses and proposes a number of amendments to the Elections Act 2011. Clause 7 has Clause 7, Clause 8, Clause 9, Clause 10, 11, 12, 13, 14, 18, and 19 have proposed amendments to sections 14, 16, 17, 19, 22, 23, 24, 25, 32, and 33 of the Elections Act 2011, respectively, by deleting the word nominations and substituting it with the words registration of candidates. This will ensure that there is a clear delineation of the roles of the Commission vis-a-vis the role of the Registrar of Political Parties during nominations or registration of candidates. This is according to the bill and the proposals that this bill is bringing forth. Members are expected to get back to the chambers to continue with the debate on these amendments that have been tabled or proposed in this particular bill. The Elections Amendment Bill, National Assembly Bill number 3 of 2022, tabled by the leader of Majority Party, Honorable Amos Kimunya. Debate was currently on before a member rose to indicate that the House lacks a quorum to continue debate on this crucial